In June 1874, Mr. Dodds offered to sell his property to Mr. Dickinson for £800. Dodds put this in writing and promised to keep the offer open until 9 a.m. on Friday. At first glance, this seemed like a straightforward deal. However, what followed created one of the most important cases in English contract law. Dodds, after making the offer, decided to sell the property to someone else, a Mr. Berry, before Dickinson had formally accepted. Dickinson, however, learned about this change through a third party, Mr. Berry's agent. He rushed to accept the offer, but Dodds refused, saying that the property was already sold. The question became, was there a binding contract between Dickinson and Dodds? Could Dodds revoke his offer even though he had said he would keep it open until Friday? This case captures the very heart of offer and acceptance rules in contract law. The issue was whether an offeror is bound by a promise to keep an offer open for a certain period, and whether revocation communicated by a reliable third party can be valid. Rule: the court considered principles of contract law. An offer can generally be revoked any time before acceptance. To make an offer binding for a period, there must be consideration for that promise. Revocation does not need to come directly from the offeror, as long as the offeree receives reliable knowledge of the withdrawal. Application: the court held that Dodds' promise to keep the offer open until Friday was not supported by consideration. Dickinson had given nothing in return for that promise, so Dodds was free to withdraw. Further, Dickinson was made aware by a trustworthy source that the property had been sold. This was sufficient notice that the offer was revoked, even though Dodds himself did not directly inform Dickinson. The law accepted this indirect revocation. When Dickinson attempted to accept, there was no valid offer left to accept. A contract could not exist because the offer had already been withdrawn. Conclusion: the court decided in favor of Dodds. The offer was no longer valid, and no binding contract had been formed. The case of Dickinson versus Dodds reminds us that in contract law, offers are fragile until acceptance is made. Without consideration, promises to keep offers open do not hold weight. It also teaches that communication of revocation can come from reliable third parties, making timing and knowledge critical in negotiations. If you found this breakdown of Dickinson versus Dodds useful, do not forget to like this video, subscribe to the channel, and hit the notification bell. Stay tuned for more case law explained step by step to help you master your studies.